We want to bring in NBC legal analyst Misty Marris. Misty, the defense has said that there's this kind of a tug of war going on between the two different prosecuting offices, right? These delays really showcase that was going on. Is that correct?
Yeah, absolutely. There's been a lot of tension between the defense having to look at the case very globally. You've got a state prosecution and a federal prosecution. And Tom, we've seen these timelines shift throughout the course of this case. Now, the state trial scheduled to go forward on September 8th, and the state court judge, Judge Caro, making it really clear, be ready. We're going on September 8th. In light of that, you get the federal court case kicked back to January in order to give that defense team enough time to deal with both. The timeline as it was starting in October on the federal case was virtually impossible given the state court case starting, right around the corner.
So a lot of questions today, I understand, about the questions that jurors are going to have to answer before they're selected to be jurors, right? The process. The defense actually wanted to go deeper on personal questions, right?
Yeah, so jury questionnaires, they're going to get sent out to about 800 people in this case, Tom, and that's a lot. And the reason being is that this is going to be a tough case to seat a jury, given how much attention there is on it, how high profile it is. So the defense really wanted to ask more personal questions in that jury questionnaire that would help them get more of a thought on each individual juror and whether or not they were the type of juror that they're going to want on the case. The questionnaires' purpose is to weed out people who have already made up their mind about the case. They have bias. They can't listen to court instructions. But then there's another piece of this, Tom, and us trial attorneys, it's called jury selection, but usually it's jury deselection. And this is the part that's a little combination of art and science, because what the defense wants to do, and prosecutors too, put together a profile on all of these jurors and make determinations about those that they want to maybe get off the jury using what's called preemptory challenges, where you don't have to explain the why. So a lot going on behind the scenes when it comes to jury selection in this case.
Well, and they also have to overcome a lot of pretrial publicity, right? Including these reports that we've had in the last few weeks that allegedly at one point the defense was submitting a possible plea deal to the prosecution and then pulled it back.
Yeah, the defense has made this point on the record every opportunity they get, going back all the way to when Luigi Mangione arrived in New York, and there was what the defense calls a perp walk on his way to the Metropolitan Detention Center. Yeah, we've got that image right there. And in addition to that, Tom, as you said last week, a lot of back and forth. Will he use the extreme emotional disturbance defense? Is there potential buzz about a plea deal? Is that true? Well, you know what the problem with that being out there in the public sphere is? Both of those things require him to say he did it. That would be part of the legal analysis. So getting past that, when you get to jury selection and what the jurors have heard and whether or not they can put that aside, focus on the evidence of the courtroom. That's going to be the challenge for jury selection.
Misty Marris, thank you very much. Good analysis there.